going to begin with an introduction for Marsha Goodman, who is going to be presenting today. And for those of you who remember, Marsha did present for us one time already in the past, and that was last year, I think it was, and it was about,
It was like in the summer, maybe so about a year
right,
and
it
a
was a
half.
June presentation, correct? So
Yes.
it was, yeah, I guess last year is very fuzzy these days.
I don't know what year it is now.
But Marsha is an attorney who specifically, I'm going to say, specifies and really her expertise is in what we call elder law. She's a certified elder law attorney. She works for the firm Fraser, Ryan, Goldberg, and Arnold. And her practice includes what we are discussing today, but which is power of attorney and advanced directives. But in addition to that, she works on many, many different presentations and law that really work and deal with what most mature adults are working on, which is estate planning, I guess, in its most simplest form, and of course, more complex, and many different things of guardianship, ward, conservatory, long-term care insurance, and other Medicare, I'm going to say, problems and events.
Issue.
And so issues, thank you, that's a better word. So I'm going to share the spotlight with Marsha, and she, if you wanted to add anything more about yourself, definitely you can add. I'll spotlight you, and feel free to begin whenever you're ready. Thank you for joining us today.
And then what about my share? Should I hit that?
Yeah, you could do that now.
Okay. Maybe. Oh, here we go. Okay. So as Rabbi said, when I spoke to you a year and a half ago or so, we talked about Medicare. This time we were corresponding back and forth. What are some issues that I'm seeing a lot of now, maybe more so because of COVID? And what came to mind immediately was powers of attorney and advanced directives. With everyone having loved ones or people that we know or people that we've heard of, younger people who were ill, suddenly ill, it brought home that things can happen to any of us at any time, and always good to have this planning in place. So let me start on this if I can. Is that going to work? Yeah. So this is just an overview. What are durable powers of attorney and healthcare directives, including what are these various documents? And we'll be defining them as we go along. Who should have them and why? What do they accomplish and what do they not accomplish? Because they don't all do everything that sometimes people think they do, or they might do more than what you otherwise think they should. And then how do you keep them current? So that's a little outline of what we're going to go over. So a durable power of attorney, sometimes called the general power of attorney, that's the document in which you appoint someone to handle your financial affairs when you're not able to. And I think that every adult should select the person with who they want to make those decisions for them. And when I say every adult, I mean everyone over the age of 18, which we don't necessarily think of people, 19 years old and 19, 20, 21 as adults, but the law does. And for those of you who know Bob Roth, he has a non-medical home care agency in town, and I know he's worked with Smile on Seniors in the past. And I mentioned him because he and I have served on many panels together. And apparently he was listening to me when we were on those panels, because when his daughters turned 18 and they were going to go away to college, he had them come to me and have them prepare powers of attorney. Because if something were to happen to them, God forbid, if they got into an accident or became ill, he would not be able to help them, because they would say those young women are adults, and unless they have named you as their agent, then you have no right to access their bank account or to pay their bills or to to turn off their cable account because they're in the hospital. So really it applies to every adult. And you want to choose someone trustworthy who has your best interest in mind. So the general power of attorney, it comes into play for real estate matters. I have elderly clients who, so they need to have their home sold. Let's say they're moving into an assisted living. Their house needs to be sold. The person who has their power of attorney has the authority to sign those real estate documents, or to pay their bills, set up bank accounts. I often use this example because I find it so frustrating. If a senior goes into assisted living and so the family says, well, we don't need to be paying Cox Communications $170 a month or whatever it's up to now because they're not home and they're not using it, they will not allow someone other than the named person with the contract to cancel that contract or change that contract unless they have the power of attorney. So it isn't just major decisions, it's even things that seem smaller that you need to have that power of attorney to do. And we talk about a general power of attorney versus a limited power of attorney. A limited power of attorney is for a specific purpose. So when I moved to Arizona, this was before the time of online DocuSign and all of those sorts of things. My husband stayed behind in Michigan to sell our home, and I gave him a limited power of attorney so that he could sign the real estate documents. That's all it was for. It couldn't be used for anything else. If he didn't use it for that, he couldn't use it for anything else. Versus a general power of attorney, all of those things that I was mentioning and maybe some things we haven't even thought of. And then we want that to be durable. What makes a power of attorney durable, and kind of is sort of the purpose of it, in my opinion, is it contains the words that this document continues in effect, even if the principal becomes disabled. We think of this as something that would be used when the person who signed it is not capable of handling those transactions on their own, that they would be disabled, but we need to specify that that's the intent. Now, that said, the person does not need to be disabled, and you can name an agent who can work in parallel with you. So I always use the example of my own mother, who was at the end of her life, very physically frail, her very poor vision, but as sharp as could be. She gave me my investment advice, her entire life. But so if she could handle a transaction on the telephone, she did it herself. But if you needed to go somewhere, if I needed to physically go to the bank, then I could use her power of attorney to go to the bank and handle that transaction because it was just very challenging for her to get out. Now, that said, sometimes people will not want to activate their power of attorney immediately. They're concerned that if someone had that authority before they really needed it, maybe it would be too tempting. And that child who had the power of attorney might think they could use the bank of mom and dad if they got a little short 1 month. Now that's illegal and they're not supposed to do that. But nevertheless, if you really want to have a safeguard in place to assure that that won't happen, you could create what's called a springing power of attorney. That's a document that does not spring into action, does not go into effect until a certain event. And usually that event is, you would say, this is not effective until my treating physician says that I lack capacity. And then you're assured that without that doctor's letter, the person who's your agent is not going to be using the document if you don't want them to. What I personally don't like about that as much is the sort of the invasion of privacy. So in order to use that power of attorney, that letter from the doctor that says that you lack capacity has to be attached to the power of attorney that's presented to the bank teller or to the real estate agent or something. And so I feel that that's not something that everyone needs to know. But that said, that's sort of the pros and cons, whether you want something that's activated immediately, even when you still have capacity, or you want to make sure that it isn't. And that's the other side of that coin. The other thing about a power of attorney is that expires upon your death. So the person who you have named as your agent on your financial power of attorney can't, once you've passed away, cannot then use that to pay bills or pull together your affairs or anything like that. Again, in these times of COVID, it's important to realize that the power of attorney, even the kind that's springing, can be activated for a finite period and then put back on the shelf. If someone very suddenly is in the hospital and there are bills that need to be paid or transactions that need to be completed, I just, in fact, visited a gentleman a young man in his 50s who'd had a stroke. He is a real estate investor, and he didn't have a power of attorney for his brother to be able to complete those transactions during that time period. But this gentleman is getting better. He's doing amazingly well. I would expect in the next 2 months, he'll be back home, back in his business, and then he won't need to use that power of attorney. He'll be able to be back in charge. So that's the financial. The next set of documents relate to healthcare. And so you hear about advanced directives, or this set of documents, which includes a medical power of attorney, a mental health power of attorney, a pre-hospital medical, sorry, that's a typo, should be medical care directive, and the living will. These are the documents in which you appoint someone to advocate for you about healthcare and medical decisions when you are unable to do that yourself. And then other documents that that memorialize or document what your intentions are as a guideline for that agent. Again, every adult should select the person who they want to make those decisions for them and document their wishes so that person doesn't have to guess. This does not have to be the same person as the financial power of attorney. Often it isn't. Many times when someone's married, it would be their spouse for both. But, you know, I've had many a client that says, one of my sons is a CPA. He'd be a great person to handle the financial, but he is not the guy for the medical. Or, you know, it makes perfect sense. Or sometimes I had a client who named her child as her healthcare power of attorney, then that child had a special needs child of his own. And she said, you know, that's too much for him to be making those decisions all the time for his own child. And then if something happens to me, so she chose someone else. And of course, that's the beauty of having these documents, is that you get to choose who you think the right person would be. Unlike the financial power of attorney, this is only effective when you are unable to either make or communicate those decisions yourself. So when you are mentally competent, no matter what you wrote down in a living will, no matter who you named as your agent, you are the person who's going to make the decisions. They'll look to you to make those decisions about yourself. I had a client once, a lovely lady, again, very frail. She was kind of not wanting to certain treatments and testing, some antibiotics, she was declining them. And her daughter called me up and said, they keep asking my mother what she wants. And I said, as they should ask your mother what she wants until your mother is unable to express what she wants. Now, this is very straightforward, if you will. You know, if anyone's ever had surgery, I had, knee surgery a couple of years ago. It wasn't going exactly as they expected. So they came out during the surgery and they said to my husband, based on what we're seeing, we could do procedure A or procedure B. Clearly, I could not have expressed my opinion then. I was under anesthesia. But what if it's someone with dementia who can speak, is verbal, but they don't understand the concepts, things that they're saying, they're very paranoid maybe, or what they're expressing about their surroundings just isn't accurate. That person also is unable to make these decisions, but that becomes much more challenging for the agent and the healthcare providers to understand, do we look to this person or do we look to the agent? And this is one of those things I wish I had an answer, but that's just something to be aware of that's not quite so straightforward about the powers of attorney. And as far as changing circumstances causing you to change the agent that you selected, that was my example with the woman with the, once these are done, we should look at them regularly. The rule of thumb is every 5 years. Boy, those 5 years go by really fast. But certainly as circumstances change in our lives or the lives of the people that we might have named, is a good time to take a look at these documents, even if you have them in place. What are some of those other forms that I mentioned? The pre-hospital medical directive, or the orange form. For those of you who go to the care facility, they literally legally must be printed on orange paper. Sometimes in the long-term care facilities, I'll see them on the folks taped to the refrigerator right near the front door. That is something that communicates to the first responders that this person does not want to be resuscitated. And this needs to be signed off by a medical professional, by a nurse or a doctor. What I explain about that is, so this is what I used to say when we could go to places. When we were together, I would say, when I walk out of this meeting and I'm like looking at my phone while I'm walking, so I trip and fall and I hit my head, I sure want to be resuscitated, because after that, I think I'll be fine. But if I was bedridden and I had a diagnosis of stage 4 cancer and I went into cardiac arrest, maybe at that time I would say, you know what, let's let nature take its course. So, excuse my, Rabbi, someone is requesting remote control of my screen. Should I decline that?
Yeah, definitely. That's someone who doesn't know what they're pressing.
Okay, thank you. So I barely have control of my screen. Anyway, so, and then a DNR, that's a physician's order, a medical. So that would be in your chart in the hospital. Often there would be a DNR in your chart. The opposite of that is a full code. Same circumstances. If that person goes into cardiac arrest, do they want to be resuscitated or do they not? And that often, if you have completed something like that, often is for that period of hospitalization and that period of hospitalization only. They would not assume that that was your intention. If you recover and go home and then you're back in the hospital in the future, if that's your intention, then you would need to complete that again. So going back, what is the healthcare power of attorney? As I said, that is where you appoint someone to make medical and end-of-life decisions for you when you're unable to make them or communicate them yourself. And same thing, that's someone you trust, someone who would be aligned with your thought process. There's nothing, I can't think of anything more personal than those sorts of end-of-life decisions. And if the person you've chosen has a different viewpoint than you're putting that person in a very challenging position and something you want to be aware of before you give them that responsibility. Now in Arizona, the person who is named as the agent does not need to sign an acceptance, which I think is unfortunate. Other states require that, and which I think is a good idea, because this is a big responsibility. Especially, I had a client contact me, his neighbor, I mean, they were good friends, but really just a neighbor, had named him as his healthcare power of attorney and never told him. And he was called by the hospital and had no idea what to do. And boy, the person had very complicated medical issues, and this gentleman stepped up. I had tremendous admiration for him. But I would not recommend that to the person, to give someone that responsibility and not have discussed it with them. In Arizona, there's a unique mental health power of attorney or behavioral health power of attorney. It's either a separate document, or it can be incorporated and you just have to initial it, where you say that this person, the person you're naming, can make the decision to admit you to a behavioral health hospital, in addition to any kind of outpatient treatment or also your physical health treatment. And we'll talk about what happens if you don't have this. I strongly encourage you to give that authority. You might think that wouldn't come up. It comes up more than you might think. Sometimes people get an infection and get like delirium related to that infection, and they need to go into the behavioral hospital to get their medication stabilized. And so you certainly don't want to have to go through a court proceeding, I'll get to that in a minute, to have that person make their question. So Don has raised his hand. What do I do now, Rabbi?
All right, I asked him to unmute. Don, did you have a question? You can unmute to talk. But it could be Don is just pressing different things. We'll wait.
Okay.
All right, you can continue. If he has a question, I'll unmute.
Okay, thanks. And then the other thing to make sure to include is the HIPAA authorization, which is the release of medical records, or for the doctor to talk to people. Again, you can sign that in individual doctors' offices. That's a form that you probably have to sign every time you go. I always wonder what they did with it the last time, who they can talk to about you and your records. But you also can have, as part of your healthcare directive, a HIPAA that someone can show to any doctor that you aren't already seeing. It doesn't have to be the same. It can be additional people. I learned this from a client, and then I've done it myself, that they had several children, 4 or 5 children. they were very clear which child they wanted to be the agent on the healthcare power of attorney. But they said, I don't want to add to that child's burden by making them have to be the conduit of all information. Any of my children can call the doctor and find out what's going on, but only the one child can make decisions if I'm not able to. I thought that was very smart and actually changed my own documents as a result. A living will, let me take a sip. That is your opportunity to document your wishes regarding end-of-life treatment if you're not able to express yourself at the time. So this often comes into play when someone is in a coma, unconscious, what they refer to as quote unquote brain dead, or they're really sort of, the person is naturally, they're not able to take food or fluid by mouth, and they're not able to express, the situation. What would you want in that situation? Would you want, as an example, to have a feeding tube and to have artificial fluids administered artificially, but if you go into cardiac arrest, not to be resuscitated? Do you not want any of that treatment? You just want nature to take its course, if you will. You want to be kept comfortable so that you're not in pain, but you don't want any of those treatments. Or my client who I just met with last week in his 50s, who had a stroke, he said that there was a point where they were saying, is it time? He used the expression people commonly use, no doctor would ever use that expression, quote, pull the plug. What he said was they wanted to pull the plug, and my brother said, no, he's a fighter. And sure enough, here he was conversing with me. This is also something that your view changes as you age, but regardless of your view, the living will is an opportunity to document what you would or would not want. As I say here, I think of that as a roadmap for the person with the healthcare power of attorney. If there is a person to have a conversation with, the doctors in the hospital, they want to talk to that healthcare agent. They're not going to look at that living will and say, I know, Marsha, you're saying that your mother wants this, but her living will says this. The living will was really a roadmap for me to feel that I understood what my mother wanted. And even that, goodness knows, does not take the place of the ongoing conversations about how you feel about those sorts of things. I know that there's a form that's in the Arizona statutes for a living will. There are halakhic forms and like workbooks for this that I know the rabbi has access to. There are many, and some of it is really just, you really could almost freeform, if you will, just, to write. And it really can include anything. And I use an example of, I have a colleague here in our firm who is still working every day, but was quite ill many years ago and was in what they referred to as a medically induced coma. And so in fact, there was no expectation that he would not get better. But at this period of time, he was unable to express himself. And in his room, they had the TV on to the news station, not of his choosing. And I think we've often heard that when someone is unable to speak, they often can hear. And so he will attest that was the case. And it was like it was torture that he was listening to the news station that he would not have chosen. And he has documented now in his living will that if he's in that situation, he does not want the television on. He wants music on, and the type of music that he wants on. You really can be that specific, and you have every right to. And again, he would not have thought of that or to put that in if he had not had that experience. And then, other expressions of your intentions: to prearrange your funeral and or burial, and to describe your wishes. For people who want to be cremated, that the default in Arizona is a burial. If you want to be cremated, then that has to be documented. If you have not documented it, then they have, and so your child comes in and says to cremate, they won't do it unless it's the majority of your children. And just other wishes about where that would be. For those of us who are not from here, maybe we would want to, maybe we've made arrangements back where we lived before, that should be documented. We shouldn't assume that people know that. And then an ethical will, that's really the legacy of your values. There is a workbook, for lack of a better word, called the 5 Wishes that many people have used, where gives you an opportunity to document what's important to you, what's important to what you want your children to know about you, what the values that are important to you. Goodness knows we are much, much more than our stuff. But these are the kinds of things that, especially when we're ill or we're facing something like COVID, that reminds us about how fragile life is, when we think we are healthy and we're going to go on, that we want to document these things that are more than just what happens with our possessions. So I've touched on this a couple of times. What if you don't have powers of attorney? I actually should have included before this, there is, for the healthcare, there is a law that it's called a Surrogacy Statute that sets the priority of who can make those end of life decisions if you are unable to do so. And the first is your spouse, if you have a spouse. Next is your children. It would have to be, if you have more than one, then it is a majority of your children. If your parents are living, then it's your parents. But if your children are adults, your adult children are priority over your parents. And then it's a long list of people. It can be a life partner, it can be a close friend. But you can see how that can get messy if there are family members who disagree as to what they think should be done, and you have not specified who that should be. And also, that relates only to that end of life decision. When the doctors are saying that the person is in a condition where it is not likely that they would recover, that's where they look to that surrogacy statute, not other decisions prior to that. Should the person go into assisted living? Should they have, if they have pneumonia, should we treat the pneumonia? Those kinds of things are not covered by that surrogacy statute. So in that, all of the rest of those circumstances, if someone does not have powers of attorney and decisions need to be made for him or her, then a guardian is appointed to make those healthcare decisions and decisions about living arrangements. A conservator is appointed to make financial decisions. The threshold, the determination of incompetence or lack of capacity for a conservator is not as high. And you can think about that with people that you know, that they may still be able to make appropriate decisions about where they live. They take their medication in a timely fashion. They have someone come in to help with meals and so forth, but they are not able to make financial decisions, or what often happens is they're at risk of someone taking advantage of them financially. That someone might need that assistance of a conservator. And in fact, I have a client now who chose to have a conservator because so she was competent enough to say, I am worried about this sort of group of family members. I want a conservator, and then it's supervised by the court, but I still want to make my own living decisions. But in either case, there is a requirement of a finding of a lack of capacity, and that's public. So this decision is made by a judge in a court of law, that at least in the old days, it's in public. Anyone can be sitting in the gallery of the courtroom. Now, not so much, everything is by teleconference, but still it's a public statement that someone lacks capacity. And the other negative, there's a whole bunch of negatives. It's burdensome, it's not inexpensive. The cost is borne by the protected person, by the person who needs the guardian or conservator. If that person has means, then that person's means are used to pay the attorney's fees of the person who got the ball rolling. And also, as I say to families when they come to me, once you've opened the courthouse door, you are no longer in control of what is going to happen. So I would say, of the people who come to me and want to pursue guardianship or conservatorship for an elderly loved one because they don't like the way things are going, I talk half of them out of it. Sometimes there's a situation where the person has powers of attorney, they've named someone, and then this other person doesn't like what that first person is doing. Now, again, if that person is stealing their money, that's a different story. But if it's just, not totally agreeing, I've had someone come to me where the person who was the healthcare power of attorney was more in favor of a little bit more naturopathic type medicine. And the person who wanted to be the guardian was wanted only sort of what we think of as traditional medicine. Now, again, if that first person was completely disregarding, doing things that were harmful, that's one thing. But if it's just a different approach, do you really want to go to court? And who knows then what the judge is going to do? And this often comes into play with the mental health power of attorney. I've had people say, well, I don't want to give someone that authority, then they're going to lock me up. So I always explain, no, they're not. You can't drop someone off at the behavioral health hospital and just leave them there. There are specific criteria for who is appropriate for admission, and they're not going to admit someone who doesn't meet those criteria. But I had one of a lovely couple where she had her husband's healthcare power of attorney. She was very petite and he was a bigger guy. And they were in a parking lot and he got disoriented. She was not able to sort of physically redirect him. And so someone called 911. The police came. The police sort of had no choice because at this point he was a little combative. They took him to the behavioral health hospital and she had to do an emergency petition for the mental health guardian so she could then, manage his care there. Whereas if she had had the mental health power of attorney, that would not have happened. I mean, they would have taken him to the hospital, but the guardianship wouldn't have been necessary. They would have gotten him stabilized and sort of that would have been that. So it's just not the road you want to go down if you can avoid it by having powers of attorney in place. And so I mentioned a couple times competency. The decision of whether someone is competent or incapacitated is a legal decision, not a medical one. So a medical decision is definitely part of it. The courts in Arizona will not appoint someone as a guardian if there is not a doctor's report that says that the person needs it. The person has a medical condition that affects their judgment. But that is just one factor. So just a medical, and I have many people say, as an example, my brother is still writing his own checks and so forth, and the doctor said he lacks capacity. Or what I hear more often is the doctor says he has dementia. The doctor says he has Alzheimer's. Many a person with a diagnosis of Alzheimer's early on in that process still has the capacity to say, I can choose the person, I can sign a power of attorney, the person that I want. And even when it's in like that springing power of attorney, or when a trust says, my successor trustee can take over when I lack capacity. And how that's determined by my treating physician and another physician who says that I lack capacity. So that's a decision that's either governed by a legal document or made in a court of law. And there are different standards for different purposes. So Arizona has a law where if someone over 65 signs a contract for a car, that person has 48 hours to rescind the contract. The law recognizes that those contracts to buy a car with all of that fine print and the salesman won't give you 30 seconds to read it and think about what you want to do, that when someone is older, that it's possible that they would be more likely to be confused and allow them like a cooling off period. So that's the contractual capacity is about the highest. On the other end, on the lower end of the spectrum, is testamentary capacity. In order for someone to have the capacity to sign a will, the law says they need to have a basic understanding of their assets, to have donative intent, and know the objects of their bounty. So that means someone knows they have a house, an account at Schwab, and a checking account at Wells Fargo. And maybe it's all worth about $300,000 altogether. They don't need to know account balances or everything. A general understanding of their assets, the intention to give it upon their passing, and to know that it would go to their children. That's the level of understanding that someone needs to have to do a will. So that's a lot less, frankly, than that understanding to read all of the fine print in an agreement to buy a car. And so it can be fuzzy, and that goes back to that springing power of attorney. When does that person lack capacity? It is not so straightforward, but still to have everything in place when you get to that point really is helpful. And that was everything that I had planned. It looks like we have 7 or 8 minutes for questions or.
Sure, and you can take more questions beyond that. People will
Oh,
stay
oh,
on.
great. Okay.
If you want, you can take off your screen sharing so everyone will see you
Yes, good
better.
idea.
And if you do have a question, I know that there are a couple. I see Rhoda already unmuted, and I know that there was a question that was sent to you in the middle in your own private chat. So if you want to look at that first, and then Rhoda will get to you right afterwards.
Okay, so I see something in the chat.
Judy, was your question answered about the durable power of attorney? Okay, so if you want to start with that, Marsha.
It was not answered?
First of all, Marsha, I want to thank you so much for doing this for us. So I was convinced to sign a durable power of attorney. When I got home and I started really looking at it, I found that to be a very dangerous document. There's absolutely nothing to prevent your executor or whoever you appoint from going into a bank as long as they have that document and taking all the money out. Naturally, we trust all of our relatives and, and everything like that, but you hear of things.
Mm-hmm.
So, I find that very, very dangerous. So it's it's recorded in the Maricopa County Recorder. So my first question is, how do I get rid of that? And can I get rid of it just by doing a new one with the wording that I want in it?
So let me, so especially since it's been, if it had not been recorded, any subsequent power of attorney overrides the previous one. That said, because it's been recorded, I would record a revocation of that power of attorney, so that there's no confusion. And that really would be just something that says, I hereby revoke the power of attorney that I signed on March 15th, 2020. And you should sign that revocation with the same formalities. So with a witness and a notary, just like the document was, and record that. And then, and again, I'm only saying that because it was recorded and you just want to make it absolutely crystal clear, because you never know who's going to, because I could go look at the list of recorded documents if I had nothing else to do this afternoon, so you just want to make it really clear to anyone who should do that, that you've revoked that one.
Now, did it need to be recorded?
No, and I don't record
so
them.
now it's been made more complicated.
I know the only time I record my client's powers of attorney is if it relates. So if someone has a power of attorney and the agent under the power of attorney handled a real estate transaction, then I record the power of attorney with the real estate documents to confirm that the signer had the authority to sign them. But the recording is just in Maricopa County. Banks are like, who knows where they really are, who knows even who's looking at it. And if, like Wells Fargo, which is based in North Carolina, are they even going to look at what's recorded in Maricopa County anyway? So I don't believe they have to be recorded, and I don't generally record them. I don't think it helps anything.
And can I put in the wording that I wanted to put in? I forget where I put it in the chat.
Said, I'm going to read it and I'm going to tweak that for you. You said, can I change only effective if I'm incapacitated? Oh, yes. And as certified by an attending physician. Yes, you can.
And do I need to change the subject from durable general power of attorney to springing?
Well, you would say you should add springing to the name. So it would be durable and springing, because those are not mutually exclusive.
And it's interesting that you didn't find a problem with the way it was. You had more of a problem with the springing power.
Well, I guess that depends on a person's experience. Because you're right. Someone could go into the bank and take anything out. The bank should, that would be question. I mean, they may or may not question. I guess it just depends. And, and it depends on, like you said, of course, we trust all our relatives. I don't trust all my relatives. I trust the relative I chose. I have 2 brothers, and there's one of my brothers I would not choose for this. He manages his money very poorly, and he would he wouldn't be malicious. He would just be short 1 month and then I wouldn't choose him. Whereas my other brother is, just fastidious and I just know that I wouldn't, and he also is, he's not wealthy, but he's not in that situation where he needs anything. So I just would rather have it be easier, but your family situation is different. And maybe everyone that you might choose, you have a little nagging concern that there'd be issues about money, and that's very legitimate. I just always want to point out the concern as it relates to privacy of having to have the doctor's letter, shown to third parties. That's the part that I worry about.
So I can type up my own documents on revoking it and have
Yes.
it notarized and signed and bring that to Maricopa County, wherever that is.
Yes, to record it again.
All right, thank you so much.
You're welcome.
And Marsha, before we take the next question, I know that there's a question that was written privately to you.
Mm-hmm.
So if you could look in your chat, it will be in the same chat, but it will be.
But it says privately.
Yeah. Do you see any?
I'll be happy to answer that because it relates to this.
Okay.
So the person asked about titling of bank accounts, which is a really good topic. Can it be titled under your own name and have the beneficiary be named, or the bank accounts only in the trust? So that sort of mixed a lot of things. So let me start back. So you should not add, other than like your spouse, if you put someone's name on your bank account. So if you have a bank account and you say, I'm going to add my daughter to my bank account to make it easier so she can manage that, I do not recommend that. By adding your daughter as a co-owner, she's a co-owner, she can go clean out that account and there's nothing to stop her. The person who used the power of attorney inappropriately for her own benefit, that was illegal. Now, whether you can catch them, all that's a factor. Here, there's nothing illegal. If you name that person as a signer, that's different. So if you fill out a signature card, it's almost like a power of attorney just for the bank account. So that if you're doing that to make it easier to manage, is the same as, if you will, as a power of attorney, but just for that bank account. Now, you can also name your child the beneficiary of an account. Arizona, you can have it's POD, pay on death, or transfer on death of a financial account to designated beneficiaries. That's a good idea. That's a very simple way to transfer that account immediately upon presentation of your death certificate that doesn't go through probate. That's a whole other topic if we want to talk about probate, but that's different. But that person whom you have named as a beneficiary does not have access to the account until you have passed away and they've proven it with a death certificate.
Marsha, that was my question, and it was partially answered, but this is what I wanted to say, that I just recently am really in the throes of doing a trust, not a will, a complete trust.
Right.
And so the attorney said, go to your bank and get it titled to the trust.
Yes.
Well, what they did was they kept my name. I mean, it just came back an hour ago from it. They kept my name as owner of the savings and checking accounts. And they put the Janet Trust as beneficiary. Is that as efficient as saying
That's
no?
not at all what they should have done. They should have retitled that account in the name of the trust. That's the purpose of the trust. So you can do a trust that way. I mean, you can do what they did, but that's not what they should have, in my opinion. The purpose of a trust is to collect your assets in the trust. And a trust not only of, like I said, this will be a whole other session, but if we ever wanted to do one, but the trust, a good thing about a trust is not only to avoid probate upon your death, but also creates a structure to manage your assets while you're living if you become incapacitated. And because you have a successor trustee who steps up if you're not able to do it. So by titling the account the way they did, completely eliminated that benefit of having the trust.
Okay, so I go back and tell them, I go back to the bank and say, I want it open up like new, as if you open up a new account with the name
Well, it
Jan
shouldn't be a
Blackman
new account.
Trust.
You should be able to bring the trust with you, show them
Right.
the trust. They see the trust, they see that you're the trustee, and they should be able to retitle your account in the name of the trust.
And then all the pensions and social security and all that, does that then do I have to change all that to say, send
So
it
now,
to?
I think we're
What are
beyond
you
the scope
doing?
of this presentation.
Oh, okay.
The answer is no. I'm going to tell you, anything that's direct deposited in that account, they don't know the name of the account. They have the account number and the routing number. And
Okay,
as
so
long
I
as
wouldn't
it's
have to
the
get a
same
new
account,
routing number or anything like that.
as long as it's the same account that
Right.
it's being, into which is being deposited, then it doesn't matter.
Okay.
Okay, so I see a subsequent presentation for January or something.
I would
Yeah.
love to. You guys are great.
Okay, Marcia, Rhoda was waiting. She had
Oh.
unmuted her mic, and then we'll get back to some of the chat questions. But
Okay.
Rhoda, you want to ask a question?
Yeah, unfortunately, after the fact, I heard that you should not keep these original documents in a bank vault, that a copy at home is not the same. Is that true? Do I need to go
Well,
get all
so
those?
Again, it depends. A healthcare power of attorney, I have never seen, you can always use a copy of that.
Okay.
The general power of attorney, usually a copy is okay, unless, for real estate, never. Any sort of real estate transaction, they'd want to see the original. So you're right, if you keep it in your safe deposit box, but the person who's your agent can't get into your safe deposit box because you can see where we're going with this. So it's actually should probably be in their safe deposit box, but it should be somewhere safe but accessible when needed.
The same with a will?
The will, in my opinion, actually not so much, because that's not really needed until you have passed away. But so you're right, if no one's going to have access to that box until they have some sort of legal authority, but they can't get the authority without that document, yeah, the same.
Okay, thank you.
You're welcome. Thank you.
And then Paula had a question. This is in the chat. If you don't have relatives in Arizona, is it important though that the power of attorney and others are in Arizona, or is it okay to have them out of state? Practical question.
It's either way. It really is most important that it be the right person. When my mother, who I always speak of as my example, lived in Florida, and I was here for the financial, I really think it's no problem. When you think of banking and all of that is remote now, and I often say, it's not like your money's in that branch on the corner. It's sort of everywhere and nowhere. And I never had any difficulty handling any of that remote. The healthcare, even that, the person that was hard for was me. It was hard to be far away. It was hard but my mother's doctors knew me and they knew that I was the agent. When she was ill, I would, the time zone was sometimes challenging. At one point I would get these phone calls, every morning at 4:30 in the morning during daylight savings time. Her doctors would call me because it was 7:30 there. And, it was hard to not be there. And then really closer to the end, it was like, I'm afraid to be on that airplane for 4 hours because then I can't even communicate. But I didn't feel that it hampered my ability to advocate for her. And so if the right person lives out of state, then it can work. You certainly shouldn't choose your, second choice only because that person lives in Arizona, would be my answer to that.
Okay, thank you. And then one other thing that I see in the chat, and I don't know if you have any other private questions that were written to you. You mentioned about ethical wills, a workbook. If there's any details you can share.
So I mentioned that it's called the 5 Wishes, is 5wishes.org. That's one workbook for an ethical will. Others, I've seen them, but I don't have a particular. You've inspired me, however, to research that, and then I'll get information to you for that.
And just to add, I think we had a presenter right after the holidays. That was magillahcom. I think that his website was also about like ethical wills and things like that.
Oh, that's
It's
interesting.
not set up the same typical way you'd envision it, but it was sort of like through videos.
Oh, like little topics.
Yeah,
Oh, that's
exactly.
neat.
So, and I think if you search it, I think you had mentioned there might be Jewish websites that have it as well. I've seen certain things about that.
I know I
Um,
had a client recently who, I don't know where she got it, but she's here locally, and she had a halachic living will form that she showed me that had come from, that she had found on the internet.
Right, there is one from the RCA, which is the Rabbinical Council of America. I know, I've seen it on their website.
Hmm.
Any other questions? If you do have a question, please feel free to type it in the chat now or unmute your mic while we see if anyone does have a question. I see, I think we've got someone unmuting. I'm just going to share tomorrow is the movie discussion group on the movie called Sefarad. So for those of you who didn't watch it yet, that is on Amazon, and that is at 11 in the morning. That is not at 12:30. And then on Wednesday, we have a local author. Her name is Linda Pressman, who will be speaking about writing a memoir with a Jewish perspective on that. So maybe that is some sort of an ethical will as well,
Ooh,
you know, to talk about what's,
I want to watch that one. So,
all right, 12:30 on Wednesday. We'll let you in.
thank you.
All right, if there aren't any other questions, I did put Marsha's information in the chat. She is an attorney at, like we mentioned, Frazier, Ryan, Goldberg, and Arnold. And I put her website entry where you can read her bio and have her contact info. If you wanted to set up any of these legal documents with her, I know that she won't refuse you as a client. So again, thank you so much. She did not pay, this was not done for any incentive like that, but I
Oh,
know
goodness,
that
no.
from speaking to some of her clients, they are very happy with her. So just
Thank you.
putting her information out there would be beneficial for you as well. Thank you so much, Marsha. And I
Oh, my
will
pleasure. Thank
schedule
you
with
so
you
much.
for, I see that trusts are a good future
Oh,
topic.
yeah, let me know down after, as you said, in the January, February, if you would like to schedule again, I'd love to.